In this courtroom hearing, the judge calls the case involving a defendant identified in the transcript as Destiny Graves in the City of Detroit court proceedings. The hearing begins with the court referencing several case numbers connected to the defendant, and the matter scheduled for today is an arraignment on a bench warrant. During an arraignment, the court formally addresses the charges and determines how the case will proceed. The judge also asks whether the defendant would like legal counsel to represent her during the process, which is a standard procedural step meant to ensure that defendants understand their rights before moving forward. However, the situation quickly becomes unusual. Instead of answering the court's procedural questions directly, the defendant begins challenging the court's authority. She states that she is appearing, specially and not generally, claiming that the name written in all capital letters represents what she calls a corporate legal fiction, while she identifies herself as a living woman. She repeatedly asks the court to prove lawful jurisdiction over her before any proceedings continue. The judge, on the other hand, focuses on moving the case forward through normal courtroom procedure. The court presents three possible paths: speaking with an attorney, attempting to resolve the matter with the city attorney, or scheduling the case for a jury trial. What follows is a tense exchange where two completely different approaches to the legal process collide.
This is the City of Detroit, Mr. Berry versus Destiny Graves, case number SB16, strike that, SB106959, counts 1 and counts 2, SB172478881, SB1724805, counts 1, 2, and 3, and SB1724836-1. Appearance for the city.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Graves.
Good morning, Your Honor. I am Destiny Raven Graves. That's capital D, lowercase ESTINEY. Hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES. I am appearing specially and not generally. I am here in good faith and under the protest solely to address the matters raised in my plea abatement. I am not here to delay the process, but to ensure proper identification and lawful jurisdiction are established on the record before any further proceedings.
All right, good morning to you, ma'am. Today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or no?
I'm sorry, can you repeat that?
I said today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or not?
I actually am not open to proceeding until we establish jurisdiction over the living woman. That's Destiny, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES.
Jurisdiction has been established if you are Destiny Graves. If you're Destiny Graves, if that's your name, then unless you have some other view of the court rule and you cite a court rule, the court is going to feel the jurisdiction has been established.
I understand, Your Honor, but respectfully, the name in all caps represents a corporate legal fiction. I am here as a living woman, not as a surety or a fictional entity. I respectfully require the court to establish, for the record, how to obtain lawful personal jurisdiction over me, the living woman, separate from that entity.
Well, I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond. I can either give you into the breakout room with the city with an attorney, and he can help you proceed, or you can proceed and speak to the city attorney yourself to see if you can work this matter out, or I can set a jury trial date and the matter will be resolved on the jury trial date. Which one would you like to do, ma'am?
Are you asking me if I would like to proceed for trial?
Yes.
I will respectfully, Your Honor, I would like to reserve all my rights under the UCC 1-308, and I object to these proceedings under protest and duress. My appearance is special and not general. I do not consent to the court assuming jurisdiction through presumption. If this court insists on moving forward without proving lawful authority over the living woman, I must note a violation of due process for the record.
Okay, so, I mean, if you can't give me an answer to my question, then I'm gonna put you back in the waiting room until you can figure it out, and we'll move on to the next person.
What is your question, Your Honor?
What we're seeing here is a situation that judges encounter more often than people realize. The defendant is relying on arguments commonly associated with so-called sovereign citizen theories, where individuals claim the court lacks authority over them unless certain conditions are proven on the record. But as the judge makes clear through his responses, courts generally do not recognize those arguments as valid legal defenses. Instead, the judge repeatedly tries to bring the discussion back to the practical decisions the defendant must make: talk with an attorney, negotiate with the city, or set the case for trial. When those questions go unanswered and the conversation keeps circling back to jurisdiction arguments, the judge decides to simply move the case aside and call the next matter. In the end, this moment highlights the tension between courtroom procedure and defendants who try to challenge the system itself rather than address the case directly. If you found this courtroom exchange as fascinating as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
I asked you, do you want to see if the attorney can get you an offer and speak with the attorney? Or would you like to work out an offer with the city yourself to resolve the matter? Or would you like me to set a jury trial date? Those are your three options. You keep on saying that same stuff is not going to change what your three options are, okay? So that's that. I don't need to hear that same recitation of what you just mentioned a minute ago. Now, what do you want to do?
So I'm sorry, respectfully, Your Honor, I do want to know, is this denying the abatement plea?
Say that again?
Is this denying my abatement plea?
I'm not getting into this, ma'am. I'm going to pass the matter.